A very good morning to you and welcome. And thank you so much for joining us for our conversation with the Judiciary of Jamaica. What is our annual media forum where we discuss with members of the media matters related to the judiciary. A special welcome this morning to the Honorable Mr. Justice Brian Sykes, Chief Justice of Jamaica, the Honorable Mr. Justice Patrick Brooks, the President of the Court of Appeal, His Honor Mr. Chester Crooks, Chief Judge of the Parish Courts, Mrs. Tricia Cameron Anglin, the Director, Court Administration Division, and Dr. Denarta Dennis, the Chief Court Statistician. I am Kadish Jarrett Fletcher, and I will be your moderator for this morning. The media represents an important stakeholder for the judiciary. It is through the media that our stories are told, what is happening within the judiciary, what is working and what is not. The media also represents the means through which we are held accountable as a judiciary to the people of Jamaica, accepting that we provide an essential service to each and every Jamaican citizen. This morning's event will feature presentations from His Honor Mr. Chester Crooks, Justice Patrick Brooks, and of course, Chief Justice Brian Sykes. Later on, following those presentations, Mrs. Tricia Cameron Anglin and Dr. Dennis, who are also seated on the platform, will form that panel which will field your questions this morning on issues related to the judiciary. So please note, we will take the questions at the end of all the presentations this morning. While we hope to field questions this morning on a number of issues related to the judiciary, please bear in mind that the members of the panel are unable to speak to any matter that is specifically before the court now. And so no court matter will be addressed this morning, only matters related to issues concerning the judiciary. As a judiciary, we have been looking forward to this conversation this morning, and so we're hoping to have a fruitful and a very frank discussion. At this time, I invite His Honor Mr. Chester Crooks, who will first make his presentation this morning. Once again, a very pleasant welcome to all.
Good morning, all. Thank you, Madam Moderator. I crave your indulgence to acknowledge that today as being the International Day of Women Judges. And if I may be so bold, please allow me to read an excerpt from the President's message as the President of the Jamaica Association of Women Judges. On behalf of myself, the President and the Chief Justice, we heartily adopt these sentiments. Today, we salute, recognize, and laud the work of our women judges. Judicial decisions at all levels have always had important consequences on policy, legislation, consumers, business, and the basic rights of citizens. Traditionally, the judiciary was mainly populated by men. This has changed as more women are serving on the bench all over the world, and Jamaica stands among those where more women are working as judges than ever before. The Honorable Chief Justice of Jamaica, Mr. Justice Brian Sykes, in his address last year to acknowledge the International Day of Women Judges, noted the uniqueness of the 3-to-1 ratio of judges in favor of women serving as judges in Jamaica. So we heartily congratulate them, acknowledge them, and hopefully we don't reach the stage where we'll have to have an International Day of Male Judges. But I think we're getting there. Fairness, independence, accessibility, and accountability are some of the outcomes an efficient and effective justice system seeks to promote. The promotion of these outcomes create positive relationships between the court and court users, which aid in the building of public trust and confidence in all courts. In this regard, therefore, the courts have continued to rely on statistical data as an essential part of its growth and in furtherance of the achievement of these outcomes, all with a view to continue improving. Towards this end, based on an examination of the statistical report on criminal matters in the parish courts of Jamaica for the year ended December 31, 2022, it would be very fair to say that the parish courts have done and continue to do very well, notwithstanding the ever-present infrastructural challenges and resource constraints. For this period under review, the case clearance rate in the parish courts, the criminal divisions, was 124.58%. Basically, this means that for every 100 criminal cases filed in the parish courts, 124 were disposed of on average. As of the year 2022, we discovered that 70% of the cases in the courts were for traffic offenses. And given the recent spotlight that was shone on the court system because of the effort to clear long outstanding traffic matters, I think it's an appropriate point to focus on. Consequently, whilst most are positive, the new system as regards the traffic matters has highlighted several challenges in the court infrastructure as it relates to the prosecution and disposal of traffic offenses. Chief among them are the volume of paperwork in the courts, allocation of space for storage and processing time. While the new electronic ticketing system will assist with reducing the paperwork at the courts, for its full potential to be realized, there will need to be the appropriate amendment to the relevant legislations in order for the courts to work in a fully digital space. Over the past few months, the traffic court has seen an influx of printouts containing outstanding tickets for the said court to address. Although I say the traffic court, I'm also speaking about the other, island-wide when the other judges sit in their traffic jurisdiction. For the period September 2022 to January 31, 2023, approximately 11,491 printouts were submitted to the corporate area traffic court alone. For the period September to December 2022, approximately 950 printouts were submitted to the court. Since the start of 2023, 11,471 printouts were submitted. As at February 1, 2023, the estimated total number of outstanding tickets from the aforementioned printouts was 385,841 tickets. This is inclusive of approximately 579 emails received up to January 31, 2023. As such, certain strategies had to be implemented to address outstanding tickets. Subsequently, a decision was taken to resume night court sittings as well as to introduce Saturday court sittings across the parish courts throughout the island, where necessary, as well as at the corporate area traffic court in an effort to address these outstanding traffic matters. In the pilot was the corporate area traffic court, where at the end of December 2022, there were night court and Saturday court sittings for the period December 5, 2022 to December 17, 2022. The said sittings were reconvened on January 9, 2023 to February 4, 2023 at the corporate area traffic court. However, in an effort to employ a more structured and practical approach to addressing these outstanding tickets, as well as to ease the pressure on the court staff and judges, while simultaneously allowing the court to better serve the court users, night court and Saturday sittings were postponed for a period of three weeks, being February 6th to February 25, 2023. During this period, efforts were made by the traffic court staff, along with the help of some hard trainees, to count the number of printouts received, peruse the said printouts to determine whether the tickets listed on same were within the jurisdiction of the traffic court, sort the various printouts in the following categories: printouts containing 1 to 5 tickets, printouts containing 6 to 10 tickets, and printouts containing 11 or more tickets. placing the said printouts in respective folders and in date order received, and locating the tickets on the respective printouts. This was with a view to bringing more order to what was initially perceived as a very chaotic situation. In addition, the traffic court received and continues to receive considerable assistance from the Court Administration Division in calling and informing court users of assigned court dates, as well as responding to queries relative to the printouts received. Further, it was noted that despite their best efforts, it would have been impracticable for the limited staff at the traffic court to undertake the search of the almost 400,000 outstanding tickets which were submitted by way of printouts to the court in recent times, so as to bring them before the court to be addressed within a reasonable time frame. As such, steps were taken for the court to embark on a special project with the assistance of the Court Administration Division to engage various persons from courts across the corporate area to assist in the execution of the said task. A number of persons were selected, and they have already commenced carrying out the said task after court hours during the week, as well as on Saturdays since February 20th, 2023. It is estimated that this project will take approximately 3 months to be completed. A decision was also made to increase the number of judges to sit in both the night and Saturday courts. As such, at the corporate area traffic court, 4 judges, including judges of the traffic courts as well as other judges within the corporate area, are now sitting each night on Saturdays to address the outstanding tickets. The traffic court at the Melbourne location, which is beside Sabina Park, currently has 3 courtrooms, and there's also one at 36 Camp Road. A container was basically retrofitted to serve as a makeshift courtroom in an effort to address in an effort to try and clear the backlog that the staff are dealing with. The traffic court situation, before I continue, let me also commend the efforts of the judges, the staff, for their almost superhuman efforts in trying to clear the backlog. When it was going down to that deadline, we have had instances where judges and staff were working up to literally the wee hours of the morning. Some actually slept at the court's offices in an effort to assist our court users at all levels in all the parishes. There's a saying that out of every adverse circumstance comes good. If anything was highlighted by this situation is the fact that while the staff have really made good with the little we are working with over the last few years, we do need more resources. We do need to look towards working in a digital landscape, not only to make us more efficient, but also to assist us to better serve our court users. We also need, at least especially in the corporate area, we need a very dedicated traffic court that is user-friendly, not only for the court users and the staff, but also it must be purpose-driven to serve the attorneys who need to use it, members of the public, and of course the court staff. This can also be expanded to the need island-wide for the other courts who, despite several challenges, have risen to the occasion. For instance, in St. Catherine, there are 2 fires there. Nonetheless, St. Catherine did very well in terms of the statistics, in terms of the clearance rate and disposal rate. St. Anne, where one of the courthouses burnt down, and again, let me commend the staff there and the judges and the leadership on the ground. They also did very well in terms of the statistics. Island-wide, there are challenges universal across the parishes. However, I have to commend my fellow judges, the staff, who, in trying circumstances, no pun intended, still rise to the occasion to help us to clear these matters, our backlog was below 2%, which is actually over the target we had aimed for and well in keeping with international standards. We nonetheless continue and will continue an endeavor to continue serving the Jamaican public to the best of our ability. Happily, we are in dialogue, constant dialogue with the powers that be, and I think it's fair to say that we are all on the same page because we are all here in the same cause, justice and the best service possible to our court users. So hopefully going forward in very short order, we should see that, well, we are aiming to work not only in a digital landscape, but also to impose time standards in order to deal with our matters in terms of differentiated case management, which we have spoken about in the past, and which I'm sure the other speakers will also refer to. Okay, thank you all. I'm watching the clock, and I think my time has run out.
Thank you very much, Judge Crooks, for that update on the happenings within the parish courts across the island, and of course, for the specific focus on the Kingston Traffic Court. We will now hear from the President of the Court of Appeal with his update and presentation on issues related to the Court of Appeal. Again, just to remind everyone that we will take your questions on all of the presentations at the end of all the presentations. Thank you. Justice Brooks.
Thank you, Madam Moderator. Honorable Chief Justice, Sir Justice Brian Sykes, judges of the Court of Appeal and the Supreme Court viewing online, Chief Judge of the Parish Court, Judge His Honor Mr. Chester Crooks, and judges of the Parish Court, Mrs. Tricia Cameron Anglin, Director of Court Administration Division, and Dr. Donata Dennis, Court Statistician, members of the media, present in person and online, ladies and gentlemen all. Let me also join my brother Chester, Judge Crooks, in saying Happy International Day of Women Judges to all of our sister judges in the jurisdiction in Jamaica and across the world. The Court of Appeal of Jamaica has in recent times received more publicity than usual, especially with the prosecution now being able to file appeals against decisions which they are not happy. As the highest court, which is based in the island, the Court of Appeal is the last resort in the justice system for most Jamaicans in resolving their disputes. The court is mindful of that position, and the judges and the staff take their responsibility most seriously. The court not only accepts that it must provide the best guidance that it can to the legal profession and to litigants in general, but accepts that it has a duty of accountability to the Jamaican people. We are now celebrating 60 years of existence, having been established on the 5th of August 1962. We had a week of celebrations in the first week of August last year, and through those last 60 years, we have grown from a cadre of 3 judges to now where we have 13 judges, including the president, and we have a staff of just about 50 persons, including a registrar and deputy registrar. We aim for transparency by giving reasons for our decisions in all appeals. The decisions are put in writing and are available on the court's website, and it is www.courtofappeal.gov.jm. In addition, The court has, since 2015, at first on the initiative of past President Morrison, produced an annual report on its work. The annual report is sent to the Chief Justice, to the Parliament, Minister of Justice, and a number of other stakeholders. It also is available online for viewing on the website. As some of you are aware, the Court of Appeal hears appeals from the decisions in the Supreme Court, in the Parish Court, and we also hear appeals from specific bodies, such as courts martial that the Army has, the General Legal Council, the Public Accountancy Board, and the Legal Real Estate Board. The appeals are generally heard by a panel of 3 judges. Occasionally, we've had cases where the appeals are heard by 5 judges, but essentially it is 3 judges. Since the onset of the pandemic, the court has heard almost all of its cases via the electronic platform. It means that attorneys and their clients are able to have their cases heard without having to travel to Kingston, especially for the rural areas. It results in saving in both time and cost. We are always seeking to improve our circumstances. The technical department of the Court Administration Division has recently significantly increased the court's bandwidth, and so on that level we are performing very well. We are also seeking to improve our performance by creating what is called a differentiated case management system. The system is designed to radically transform our court processes. It will help to reduce delays and eliminate the backlog of cases which has been plaguing the court for some time. Essentially, DCM, which is what we call the differentiated case management system, is a set of principles and techniques that proportionately matches court resources to the various types of cases, depending on the level of complexity. The aim is to achieve greater efficiency in the processing of cases, reducing delays and backlogs, and generally promoting efficiency in the delivery of the service by the court. And the DCM is designed to help the courts in general, but the judiciary in particular, to 1, more efficiently process the cases, 2, reduce the number of adjournments, 3, reduce delays and backlogs, and 4, provide sound, timely judgments and efficient court services to all our people who seek to use the courts. We say that the system provides different paces for different cases. We are in our 2nd term of using this system, and we have had some positive results. We have established stricter standards for single judges of appeal to turn around applications which they have to consider for leave to appeal. And starting last term, we have had special panels hearing one of the categories of cases, the simple expedited appeals. And the important thing about this particular track of simple expedited appeals is that the judges who hear those appeals will more often than not deliver their decision on the same day that the appeal is heard. The result of these initiatives is that we have significantly shortened the time that these cases will spend in the court. We had 3 such sittings of the court last term. In that time, in those sittings, 11 cases were heard, 8 of them were disposed of during the same week of the hearing, and a similar arrangement is set for this term. So far, we have had 11 cases heard and disposed of, and judgments reserved in 2 more. For the cases in this track, the judgments are usually given orally, and they are later reduced to writing, and as I said before, put on the court's website. Oral judgments are usually used when the law is settled and there is no complexity to the case. This type of judgment has 2 beneficial effects. Firstly, it provides a speedy decision to the parties, and secondly, it allows judges to have more time to work on the cases in which they have to do written judgments. The point here is that with the DCM, no case should be in the Court of Appeal beyond 2 years after the receipt of the papers from the trial court. The second major initiative that we have undertaken in pursuing the implementation of efficiency is the creation of the use of the judicial case management system. And Dr. Dennis is the expert in that regard. But it is expected that when this is fully implemented, it will allow attorneys and other people who wish to use the services of the court to file their documents electronically without having to go to the court building. It will also give judges and court staff easier access to documents which form part of the court files. That allows for rapid reproduction of sections of the documents which need to be quoted in producing judgments. This is a major step in achieving a paperless court. We're having some teething pains, ladies and gentlemen, but once we cross that hurdle, we expect that we will be up and running with a much more efficient system. Another initiative of the court is the streamlining of its process by reducing the time allotted for oral arguments in court. That means people like Mrs. Jackson Miller will have less time to address the court. We're using more endorsements and memoranda of reasons instead of written judgments. We're using standard templates for outlining the law where that law is well established. And the whole idea is to shorten the judgments so that they can be produced more quickly. Starting next term, we will also be including keywords or catchwords in our judgments to aid researchers in finding the cases which deal with their particular issue. I must say that with the significant assistance of the chief court reporter, she recently resigned, but she and her team provided great help in clearing the backlog of the oldest cases in which transcripts were outstanding. In the last year, we have had over 63 transcripts produced and received by the court, and a number of them were for long outstanding cases. Ladies and gentlemen, we have a great team at the Court of Appeal. I must, however, single out the judges. We pride ourselves on being a family. We work hard, but the judges work in addition to their daily exercises. They work nights, they work weekends, they work public holidays in trying to serve the Jamaican people. And I wish to thank them and the court staff for their efforts. I have some statistics which I got just this week, which shows that we are heading in the right direction. And if you ask me, I'll tell you. Thank you very much.
Thank you very much, Justice Brooks, for your presentation and that update on the Court of Appeal. Our final presentation for this segment of this morning's event will come from the Chief Justice. But just to remind you, if you're just joining us, we will take your questions at the end of all three presentations. So with the Chief Justice making the last presentation, following that we will open the floor for questions from the members of the media who are present with us this morning. Chief Justice.
Thank you very much, Mrs. Jared Fletcher. President, Chief Judge of the Parish Court, Mrs. Cameron Anglin, Director of CAD, Dr. Dennis, members of the media. Welcome to this, our third, I think, event of this nature. And what we are seeing here is the way in which modern judiciaries operate. And the whole question of the accountability of the judiciary is managed in a different way in comparison to the other arms of government. The other arms of government, they are elected or nominated, depending if you're a senator, and so their accountability comes through, not primarily but not only through the ballot box, the press, and other means. Where you have an appointed judiciary, the accountability comes in this way. One, through engagements of this nature. Secondly, the publication of statistics, which are on our website, which you can examine at your leisure, and then also in response to questions that persons may ask. The President of the Court of Appeal referred to the whole question of written decisions, or at least a summary of the decisions as to why a particular case was decided in a particular manner. That is also part of the whole question of accountability. And so this is the way that we'll be operating going forward, and it is also one of the important markers identified in the International Framework for Court Excellence, which you can look up on the internet. It's the IFCE, and it sets out their standards for modern judiciaries. And while we mentioned that that is an organization that I had mentioned in 2018 or 19 that would be joining, but we intend to complete that process this year so we can become members of that body. And what that means is that we are indicating to the population at large and to the world at large that these are the standards that we are aspiring to meet. And so that's another way in which we're held accountable. And the whole question of sustainability, because once you achieve a particular target, the question then becomes, how is it sustained? And then this is where now becoming ISO certified, because we are taking steps to become ISO certified in a number of our courts, the Court of Appeal, the Gun Court, the Hanover Parish Court, the St. Thomas Parish Court are the first courts identified to commence that process of ISO certification. And essentially what that involves is the documentation of our processes, and it will be known. So processes relating to just about all aspects of the court's operations. So when you're applying for a spirit license, for those of you who may be interested in earning in that way, it won't be any mystery as to what the process is. You're applying for letters of administration or a grant of probate, no mystery as to what the process is. So all of that will be outlined, and the time standards. And one of the critical things about ISO certification is that you have to subject yourself to an audit annually, and then you're recertified every 3 years. And so those are the ways in which we are improving our operations and holding ourselves accountable. Now, the President spoke of the question of transcripts, and that has been a long-standing problem within the courts. The truth of the matter is that the way in which evidence is recorded in the parish courts and also in the Supreme Court has become a bit dated. That is just the plain truth of the matter. And so this is why now there's a drive to move to a digital recording system. Now that is going to require not just the initial investment in terms of equipment, in terms of training and so on, but also a change in culture. Or courtrooms, oftentimes during trials, sometimes you have the conversation with members of the bar and you have this sort of buzz of conversation in the courtroom. For digital recording to work efficiently and effectively, it means that the courtrooms will become virtually as silent as the grave, because it means that it is essentially, for those of you who are in media and particularly working in a television studio, essentially the court will be a combination of what happens in a studio with what happens in a court. So you can't have too much noise in the court environment, and each microphone will have to have its own channel. You would know far more about this than I do. So that is what will be needed for an effective digital recording system. Means that you have to have a different occupational group. Would be now digital recording clerks. Those posts have been created, and they would have to be trained now to annotate the record. So when an exhibit is being entered, you annotate that. When cross-examination begins, it is marked. So it is both date, time-stamped, and whatever the particular event that is happening in the court, it is captured. So that will now require significant investment in terms of storage and retrieval, and the whole important question of what is the official record of the court for that particular trial. Does it include all the exchanges between the lawyers and the bench? So you may have something arising that not necessarily connected to that particular case, but it may have arisen during a particular case. Does that form part of the record? So those are things that we are working on. We have also developed developing a job description for a new occupational group known as transcriptionists. So these persons will be coming to our courts certainly in the next 12 to 18 months, if not before. And that will go a far way in eliminating this problem of delayed transcripts or unavailable transcripts, because one of the problems that we have had is this. For those of you who have been to the Supreme Court, and you will notice the court reporters are there taking the evidence. If you look at the machine, it's not a typewriter. It has a limited number of keys. And in that discipline, there is no standard way in making a keystroke for a particular word. So let us use where, for example, and you have W-E-A-R, W-A-R-E, W-H-E, W-H-E-R-E, and you have W-E-I-R. So different court reporters can key in any of those words in the way that is comfortable to them. The discipline allows that. And so you find that you have a dictionary, and the dictionary is tied to the machine. So you find this is one of the reasons why court reporter A can't necessarily use the machine for court reporter B and the computer and so on, because it's configured differently. So we have not had a practice of actually producing transcripts as a matter of course. What would happen is that the evidence is taken, and if the person is acquitted, then it isn't turned into a transcript in terms of English characters. It's just there. But somebody may come along 5 years later and say, oh, you know, I need a transcript of the particular trial that took place 5 years ago. By that time, the court reporter may have retired, the court reporter may have migrated, and so it becomes increasingly difficult to produce that transcript. So what is involved here now is sort of changing that, because we still have the court reporters in the system. They won't be replaced, but they are still there, so they are still members of the court family. But we'll have to change the standards now by which they work, and so produce a transcript as a matter of course, so that in the event that a transcript is needed, it is there. So those are ways and means now of dealing with the question of transcripts, which really means in practical terms that you are going to hear about cases where persons have been convicted in the trial courts, but there are no transcripts for the Court of Appeal, and those appeals will quite likely go down. So just to say that that is likely to happen, certainly in the next few months coming up, but that is a solution now to prevent that happening going forward. And that brings us to the question of the technology in the courts. The President spoke of the JCMS, and that system recently introduced, and it's not a bad system, but there are better systems. So we are looking forward now to another system which we saw in Rwanda and a similar thing in Spain. And essentially what that is an integrated system in which the major justice actors are connected into it: the police, the prosecution, the courts, and the Department of Corrections. So those were the four main actors on the criminal side. And then you have other persons coming in, such as attorneys, unrepresented persons, and those who need to interact with the court. And one of the advantages of that is, and the attorneys here will tell you that when they come to the civil courts, they hear it quite frequently, Judge, we can't find the file. So when you have an electronic system, now it's fine, that problem is virtually eliminated. So that again means reconfiguring our processes. It may mean practice directions. It may mean altering some aspects of the civil procedure rules to make that happen. So these are ways in which we're going to be using the technology to improve service delivery. And this feeds in now to the question of the role of the Ministry of Justice as it relates to the judiciary. And from my perspective, two of the primary roles of the Ministry of Justice is to provide adequate infrastructure. For those of you who have been down to adequate infrastructure now for the court staff and those who use the court for court purposes, because and I'm very specific in that way, because if you go down to the Supreme Court, you will see a number of our citizens who make excellent use of the court building, but not for the purposes of litigation. They are usually gathered along the Barry Street side of the court, and they gather there late in the evenings from about 6, 7 o'clock, and they enjoy the surroundings right up until the following morning. So that's not what we really have in mind when we talk about using the court and the infrastructure. So something will have to be arrived at in dealing with those of our citizens who are there, because they pose a challenge to attorneys and to court staff when they want to come in to the court building. But it's really talking about providing adequate infrastructure to house all the occupational groups. In the past, our courtroom designs were largely based upon the idea that the court is just for the staff and for the judge. But the truth is, a court is also a workspace for attorneys, for police officers, probation officers, and a lot of other persons spend significant hours of the day within the court. A provision will have to be made for that. So we're talking about the whole rethinking and redesigning of our court buildings. We shouldn't have a situation where defendants, witnesses, lawyers are all using the same space as happens in the Supreme Court when persons are being brought from the cells up into the courtroom, rubbing shoulders with the lawyers, witnesses, jurors. So we have to change all of that. That is why we need modern court buildings to deal with all of those types of issues. And the other thing now is in respect of the case management system and the decision making within the ministry, because we have now gone to Spain about 6 months ago, to Rwanda about 5 months ago, and a definitive decision as to what we are going to do with any of those systems still not yet made. So, and that is now going to require significant outlays of money, certainly in terms of building out the infrastructure for the electronic case management system to operate it. So those are the things that I think the ministry would need to become more proactive in. And the last thing that I'll speak about before I resume my seat is the rethinking circuit courts and how they operate. I think we have to recognize and accept that the 3 or 4 weeks per term, which would work out to about 12 weeks for most of the rural parishes, or 16 weeks, that is definitely insufficient now. In times past, certainly when I spoke to Mr. Phipps many years ago, when he spoke about his time as a prosecutor in the Office of the Director of Public Prosecutions, he said that he would go out and he would go to Manchester, spend about 2 weeks, and you go down to St. Elizabeth, you spend another 2 weeks, and then you go down to Westmoreland. That is how few cases there were at that time. That is definitely not the case now. There used to be parishes where they're known as light circuits, like Trelawney. It's no longer the case. Trelawney has 140 cases. St. Thomas has over 200 cases. So they're no longer light circuits. So the whole question of just 3 weeks and 4 weeks won't work anymore. As to what the configuration is, we'll have to have a discussion about that. And so what I'm really saying then is to, at the very least, we should be looking at major trial centers and taking advantage of the improved road network. So you may have a case, for example, that takes place, let's just say, on the border between, let's say, St. Mary and Portland, right at Dover. For what you might have and it is on the Portland side of the border. But the majority of the witnesses, and perhaps the defendant, may be from St. Mary. But as it presently stands, the case would go to Port Antonio. So what you would have is perhaps the witness and the defendant traveling from St. Mary to go to Port Antonio. Now, to get to St. Mary, either the prosecution or the defense would have to make a change of venue application. In the modern world, that shouldn't be so. If it is that most of the persons involved in the case, or all of them, are from the particular parish, then why shouldn't the case be tried there? So those are some of the considerations now that we have to begin to think about in terms of how we deliver legal services. So thank you very much for listening, and I await your questions.
Thank you very much, Chief Justice, for that presentation covering so many issues. Now, while we prepare to open the floor for the question and answer session, just to remind everyone who is present, your questions are not limited to what you would have heard in the presentations this morning. However, please be reminded that where there is a matter that is before the court, the panel, the members of the panel are unable to address any specific issue in relation to that matter which may be before the court. Now, at the onset, we will take 2 questions per person. Once time allows, then you can always come back to the microphone and ask any other question that you have. Just to remind you, Dr. Denarta Dennis is to my immediate left. To his left is the President of the Court of Appeal. Going across, there is the Chief Justice, His Honor Mr. Chester Crooks, who is the Chief Judge of the Parish Courts, and Mrs. Tricia Cameron Anglin, Director of the Court Administration Division. In the event you wish to interrogate the data that has been presented some more, Dr. Dennis is the best person placed to respond to those questions this morning. And so he'll be here to provide that kind of information, detailed information, should you require that. All the other members of the panel are open and here to field your questions this morning. There is a roving microphone, and so once that microphone is in your hand, we will just ask you to stand, identify yourself, indicate the person to whom you are posing your question, and then you can proceed with your question. So the floor is now open for questions to any member of the panel here present, and the mic is to your left.
Morning.
Good morning.
Alicia Dunkley-Willis, I'm from the Jamaica Observer. My first question is to Mrs. Anglin, and it relates to the issue of jurors. It's a recurring one, and over recent times we've been hearing that cases are brought up, and when there's the empanelment, there's insufficient jurors in the pool. I want to know what is being done to address that, or how best it can be dealt with. Also, there is a feeling that the stipend for jurors is a bit low. We know it's a civic duty, it's not an occupation per se, but given the times that we're in, how can that be addressed in terms of maybe recommendations being made to the Justice Ministry in that respect? Also, I have a further question. I think it will be for Justice Brooks as it relates to the DCMS. You said that there, in terms of implementation, there's a time frame that you're working with. You didn't say what time frame. Could you elaborate, please?
All right, so Mrs. Cameron Anglin will go, and then we will come to President Brooks.
Okay, I thank you for the questions that you've raised. Let me address the matter of the jurors. We have had challenges in recent times and in the past with settling the juror list, being able to identify where persons are located given the challenges with addresses that are provided and the database that we use. We have reached out to our stakeholders. We are cleaning the list. The judges have also been trained and sensitized, as well as the staff in more recent times. We have expanded the list so we can be able to reach the jurors where they are and get more persons coming in to serve. We have also strengthened our stakeholder partnership with the police so that in terms of service and finding the jurors, that can be buttressed to provide the respective courts with the jurors that we need to carry the matters forward. We have increased the number of persons working within our criminal registry as well to be able to deal with the numbers themselves, so we are able to find persons and have them ready for the court. So this circuit was impacted, and these strategies that we've put in place, we expect to see the gains from them in the next round of circuit coming up. And it's a challenge that we recognize because of the COVID-19 pandemic. We would have lost a lot of people in terms of contact information during that time, and we would have gone to places to serve them, and they're just not there anymore. And so we are looking at strategies with our stakeholders, the TAJ, as well as the police, and of course our court staff, to be able to locate these persons and have them come to serve. Immediately we have employed different strategies in terms of the list itself to be able to get a wider cross-section of persons coming in to serve. So that is in relation to your first question.
Stipend.
As it relates to the stipend, we recognize that it is really low. And so we have made representation, and I can report that the Minister of Justice and the National Council on Justice, they have been looking carefully and keenly at the stipend provided for jurors. And very soon we will hear in Parliament, in Cabinet, a decision taken on the increase in the juror stipend, because we recognize in the increasing challenges in the fiscal space that we have, the jurors just can't afford to come to court to serve. We have had to assist many of them, especially in the rural areas, getting to court and actually getting them back home. So this is something we have put as a court administration division to the powers that be, and they have responded favorably to the reports and to the submissions we have made for an increase in the juror stipend.
All right, thank you very much, Mrs. Cameron Anglin. I gather there may be some persons, maybe members of the media, who are joining us online. If that is the case, then you may feel free to go ahead and post your questions in the chat, and as much as is possible, we will do our best to accommodate those. Justice Brooks?
Thank you very much for your question. Thanks, Madam Moderator. The JCMS is having a little difficulty in terms of the Court of Appeal right now. The system requires us to scan into it all the documents which we currently have on file in the court. Mr. Earl will know that the Court of Appeal has in its files a huge number of paper, huge number of documents, a lot of paper. To scan them, especially the larger files, will take over an hour, 2 hours to scan one file into the system. So that's the teething pain, that one of the teething pains that we're having. Our staff is doing that in addition to their day-to-day tasks, and so it is taking longer than we had expected. There's also some other issues which we'll address in terms of the delay. So to answer your question, is the time for the Court of Appeal to put in these documents. We're expecting that certainly by the end of July it will be finished. In terms of the other issues, I would have to defer to Dr. Dennis to explain the other aspects of the JCMS.
All right, Dr. Dennis, do you want to speak to that now?
Well, there's a specific issue that responds.
Well,
the time
frame
for implementation.
Well, the time for implementation is a bit of an open-ended item right now because of some of the issues that the Chief Justice would have mentioned in terms of alternative systems being explored, which might be able to better serve the interests of the justice system in terms of integration of the various justice partners. So it's a bit of an open-ended item right now.
Okay. All right. Thank you very much.
Good morning, everybody. I'm Roxanne McLean from the Jamaica Star. My question is to the Chief Justice. Is the new Firearm Act practical in the sense that non-fireable imitation firearm can tie the hand of a judge? That's one. Second one is around, do you think that the sentencing guideline for white-collar crimes is it hard enough to deter people from committing these crimes who have access to big money?
Well, let us take the Firearms Act. What you have to recognize is that legislation is the product of a policy taken by the cabinet and presented to their parliamentarians in the form of a bill. So we don't have any input in that. Where we come in is whenever someone is arrested and charged and placed before the court. Now, as to whether it is effective or ineffective, time will tell. I suspect that as the cases begin to come through the courts, we will see how it is working. But what I can say to you is that harsh penalties in and of themselves doesn't have any impact on crime. It never has. What is important is that the whole process is effective and efficient. So let us use an example. In Jamaica, when we had the death penalty, mandatory death penalty for murder. But years ago, murders were very low. Now it's over 1,000 per year. So even when we had the death penalty, it didn't deter persons from committing murder. So what you need to have is an efficient system end to end. So when you look at the whole process from arrest right through to trial and appeal, how efficient is that process? And where we tend to have significant delays, because when you look at the report from at the Supreme Court, it will indicate to you that when the criminal cases now are ready for trial, they actually move on very quickly. The delay comes in the build up to the trial. And so what the data is telling us is that third-party actors are now responsible for significant delays. For example, defense counsel absent, disclosure to be made by the prosecution, various certificates to be provided. Those are the things that are hampering now the rate at which the cases can move on once they enter the court system. So if you have that improved and the time between arrest and trial is actually within our time standard of 2 years, I suspect it will have greater impact regardless of how severe the penalty may be, because if I am a criminal, for example, and I realize that these things are taking years to come on for trial, why is that a deterrent? It doesn't matter what the penalty is. The question is, will I be tried? And will I be tried in an appropriate time period? That is really the question. So penalties in and of themselves, while they need to be appropriate, but harsh penalties in and of themselves have not deterred people from committing crime. If that were the case, we wouldn't have any criminals today. Human beings have been around a long time. And in respect of the white-collar crimes, two things you have to bear in mind. One is a constitutional question. Most of those cases are tried in the parish courts. Those courts are the first major trial courts. And going back to this, not to turn you into a lawyer now, but one of the famous cases in constitutional law in Jamaica, Hines and the Queen, where it spoke about the level of sentencing that a judge at the then resident magistrate, now parish courts, can impose. And they were saying that since the judges in those courts do not have the same level of protection in terms of security of tenure as a Supreme Court judge, then it would have been, that is one of the reasons that it would be inappropriate to give them very significant powers of sentencing. So translating all of that into English, what it means is that there'll always be a cap on what the judges of the parish court can impose. It's because you don't want to give them the powers now of sentencing that would take them into the realm of the Supreme Court without also giving them the same level of protection in terms of security of tenure and so on. So you're always going to have that cap that is there. Now, there's also other principles of sentencing you have to bear in mind. If the person is a first offender, then the law suggests that unless this crime is absolutely outrageous and way beyond the norm, the maximum penalty is not usually where you're going to end up. So if they have no previous conviction, most reasonable people would think that your previous blemish-free life should count for something. And the counting for something usually means that you do not get the maximum penalty. If the person pleads guilty, then you have to have a discount there as well. So where you have the maximum penalty in the parish court ranging from 3 years or 5 years, then you're going to have that question there as to the limit that you can impose there. Now, if you bring those matters into the Supreme Court, the question is now going to arise in terms of time, in terms of efficiency of those types of trials. So those are things that you have to think about. Now, that there's the option of consecutive sentencing there in the parish courts. Again, the principles of law outlined by the Court of Appeal in a number of cases would have addressed that. So I don't know if I've answered your question, but those are the considerations that you'd have to keep in mind. To trial and not necessarily how harsh the penalty is, though, as I say, the penalty needs to be appropriate for the crime and the person.
Okay.
Good morning, everyone. My name is Maya Chung. I am representing PBCJ. My question is not necessarily to an individual. You're talking about a lot of esotericism and a lot of change over, and we've had flaws. We want the law to work for the people and give them justice. When you're talking about the types of changes that you have outlined here, just in brief, and that's not all, are we looking at government funding in the main to pay for the things that need to be done? I'll give you an example to the panel. The JDs for the, back in the day, you used to call them court stenographers, or, yes, right. That is no simple task, and that's one element. Are we looking then to partner with overseas countries? The government of Canada gave us some money recently to deal with issues of restorative justice. What are we saying here? Because this is no small task. And when we sit here, and persons are listening in, some of us are streaming, the law is for the man in the street. 70% of the cases before the court are traffic tickets. That's a big thing to look at. So is this budgetary, is this GOJ, is this partnerships with other countries? Because we need resources. We need not just monetary, human, intellect, procedural, all of that. My second question is there a plan, because there's a multiplicity of things that have to come together and cohesivize to do a secretariat, for want of a better word, because we're here to give the people understanding. News that can use laws that apply and things that are fair. Is there a common body? Has that ever been thought of? Did I miss the memo that where we have a panel of persons that are overseeing? These are just a few of the issues that you've mentioned because of time, and there are much more. Is that a thing? And anybody can take it, because, like I said, it's the generalization of what has been said here today.
Okay. Well, let's start with the question of whether there's a plan and whether there's a body. This is when we spoke about ISO certification and the Court Administration Division. The Court Administration Division was made embodied in law in 2016. And if you look at the amendment in 2016, it is really designed to provide corporate services for the courts. So part of the ISO certification now is to transform, as part of that process, the way in which the Court Administration Division sees itself and how it relates to the courts. So the question of strategic planning, the question of the management of accounting records, the question of human resource management, the question of providing administrative support for the courts. That is really the core function of CAD. So where we are now is getting CAD to perform that role, the maintenance of court property, because we have 57 courtrooms, and the courts are one of the single largest employer of persons in the public sector. It has 1,600 employees. Most persons didn't know this. I didn't know this until recently. 1,600 employees on almost 2,000 posts. Yes? So that is what the Chief Justice is presiding over. So that is what CAD is designed to do. It also provides strategic planning services, and there's a recently employed strategic planner over there. So yes, so that is the framework within which a lot of this will be operating. We also partner with the Ministry of Justice, and this is where now I think, and this is not by way of criticism, it's just a fact. You don't have to take it from me. You can go and look at the records down at Parliament or the Ministry of Finance. Every year the Ministry of Justice returns literally millions of dollars to the Ministry of Finance. I mean, that is just a matter of record. So the question is, why is that happening when the courts are in the state that they are in? That's an important question to us. So from my standpoint, the question is not so much a shortage of resources, because if you're returning millions, it means that the resources were allocated and we're not using it. So why are we not using it? So you might not get everything that you want in any 1 year, but the question is, over a period of time, have the resources been provided? And other than the things that the ministry is immediately responsible for in terms of the infrastructure and so on now, I think the answer is yes. So this is why strategic planning now becomes important. This is why with the strategic plan from 2019 to 2023, this is the final year of that strategic plan. And some of the things that the president spoke about, that the chief judge of the parish court spoke about, when he spoke about differentiated case management, that came out of the strategic planning. If you look at it, it's online, you will see that was one of the major things that we were to put in place, but the pandemic came along and we had to now switching to online and trying to keep the courts open. But we are now back to that. And the whole idea is using resources effectively and efficiently. So when the president spoke about matching complexity of the case to the resource necessary, that is what you're really talking about. How are we going to spend the public's money more effectively? So that what should happen is that the less complicated cases, let us use a practical example, an unlawful wounding in the parish court. More often than not, those cases have usually a maximum of 4 witnesses: the complainant, a supporting witness, the police officer, the defendant. And the defendant may have a witness here go up to 5. The only document that is really required is a medical certificate. And where the defendant is saying, well, it's self-defense. The defendant is not really saying the person was injured. The person is saying, yes, the person was injured, but I was acting in self-defense. So in a situation like that, those cases should go through faster. So you don't need to wait on the medical certificate, because nobody is disputing whether the defendant got an injury. But if you move on now to a fraud case, we're going to be having records from different financial institutions. You may have a question and answer being done with the police, and you're going to have all sorts of experts coming in now. Those cases will take longer. So part of the differentiated case management now is to allocate judicial and other resources depending on the level of complexity. So the simple cases should go through fast, and that is what has happened, in fact, in the parish courts. That is why over 80% of the criminal cases in parish courts are actually disposed of in 12 months. So we are now at the point where we are looking at reducing the time. The time standard across the judiciary generally is 24 months from point of entry to point of disposition. But we are now looking to get down to 15 months for the more complex cases in the parish courts, and to about 9 months for the less complex cases. And that now depends upon our stakeholders, attorneys, documents from third parties such as the forensic services, and so on. So if that happens, then you can get the time down. And to come back to the question that Mr. Goswell? McLean asked about the deterrence. Once you compress the time now, and a person who is arrested knows that once I'm arrested, this is the type of case, trial is likely to take place 90 days time, 80 days time, that is what is going to have the impact and deterrent on people's behavior. So that is, so you don't necessarily need more, as in more dollar resources, though that would be welcome. But the critical thing is, for what we have now, are we using it as effectively as we can?
We'll come back to you, Maya. I have a couple of hands ahead of you.
Good morning, Ricardo Brooks, Nationwide News. Chief Justice, you've spoken favorably in the past about judge-alone trials.
Yes.
Members who practice at the defense bar raise the concern that your ranks, judges, you overwhelmingly come from the ranks of prosecutors. I'd like you to speak a little bit more about that, and if you think there's any merit to that argument. 2, were it up to you alone, do you think we are getting to a place where we will abolish trial by jury? And 3, the executive seems to think that mandatory minimum sentences is a response to our high crime rate. Do you foresee any challenges in terms of your hands being tied? The policymakers had an argument in Parliament about whether they were tying your hands in the judiciary. Are they?
Well, let us start with the last question, the tying of the hands. Well, once you have a mandatory minimum, then you have a floor below which you cannot go. And these questions have been raised in Trinidad, the Republic of Trinidad and Tobago, and I think the Court of Appeal there actually found a mandatory minimum to be unconstitutional. The argument is that it does not allow in the sentencing process the circumstances of the particular individual to be taken into account sufficiently so, because that was the problem that the Privy Council had with the death penalty. For example, so when you have a mandatory death penalty, a homicide can take place in an infinite variety of circumstances. So similar argument may arise. And so what it is saying then, and this is a question for not just for judges, but for people generally, members of the public. So you, and many of us don't seem to appreciate how easy it is to become ensnared in the law, with criminal law. So for example, youngsters go out on a Saturday night. One has a bag, and he says to his friend, hold on to this for me. And just as you take the bag, the police arrive. Did you have the bag? Yes. You are going to be going to the court now to say to the judge, boy, I didn't really know what is inside there, you know. He just gave it to me, and probably that friend can't be found. Now, think you going before the judge, and the judge may be saying, I've heard this story so many times before. What do you think the judge is going to do? Think about it. So that may be an 18-year-old, a 19-year-old. So where we are now is with somebody who has a silencer or a magazine potentially can end up with the same sentence as somebody with an AK-47 and an M16. It's a question for the society whether you think that that approach is proportionate, but we have to apply the law as it is until somebody makes a constitutional challenge, and then we'll see how it pans out. But those are questions not just for the judges, but for all of us. So it can be your son, it can be your nephew, it can be your neighbor, it can be any one of us. You may lend your car to your friend, and you don't know where the friend has stopped, who they have picked up, and the police search the vehicle and they find a bullet or two under the mat. And of course, you are going to be saying to the judge, I lent it to my friend, don't know where he went or she went. And the judge has heard that story 1,000 times before. All right, so that's one. Now, the other question was in relation to the
judge alone trials.
Well, it's not for me, because this is what has been happening in reality. Over time, you have seen a shift of cases from jury trials to bench trials. And don't take it from me, you can go and do the research and look at the jurisdiction of the parish court, then resident magistrates court. And you will see that over time, and if you look through the law reports, you will see, whereas in the 1960s, robbery with aggravation used to be tried in the Supreme Court. Robbery with aggravation is only tried in the Supreme Court or in the gun court in the context of a gun crime. So even though the Supreme Court has jurisdiction and that jurisdiction remains, those cases don't come there anymore. Burglary hardly comes to the Supreme Court unless it's in the context of a sexual offense, and more often than not, the persons are not indicted for the sexual offense. It's just part. Yes, for the burglary. It is presented as part of the aggravating circumstances of the sexual offense. So the reality is that over time, what we have seen is that more and more cases that used to be tried by judge and jury, tried by judge alone. So when you give the parish courts coordinate jurisdiction with the Supreme Court, in effect, what you did was to say to the prosecution, you choose the forum of trial, and they have chosen bench trials. That is why fraud cases hardly come to the Supreme Court. Because prior to the recent case that came down there, the last fraud trial, I think, was about 10 or 15 years ago. That dealt with largely in the parish courts because they give the prosecution the option. So I'm not saying it's a good thing or a bad thing. You look at human trafficking. Remember, human trafficking started out with judge and jury. And then they've switched it now to being a bench trial. The anti-gang legislation is a bench trial. And then other thing to think about is this. In the context of the anti-gang legislation, the law speaks about what you call facilitating serious offenses. You have this position now where, let's just say, suppose it is the serious offense you have facilitated is a murder. So the Crown would have to prove the commission of the murder as part of the facilitation. But because it is a bench trial, the person can't be prosecuted for the actual murder. So what this really means is two trials. So you have the prosecution under the anti-gang legislation for the facilitation of the murder, which you have to prove as part of the ingredients of the facilitation. So that's trial number one. And then if you want to prosecute the person now for the actual murder, then now you have to have trial number two. And that is with a judge and jury, and the first one is a bench trial, essentially the same witnesses. And so, what is the risk there? Inconsistent decisions. So a judge may say, oh, I don't think the facilitation is established, but the jury may say, well, I think the murder has been established. So these are some of the things you have to think about. So it's not for me, but it's just to look at what is happening, and that is why I said sometime in the past that there does not seem to be a coherent policy in determining which matters are tried by a judge and jury and which matters are tried with a judge sitting without a jury. And the other question as to whether judges coming from the prosecution are more likely to convict.
Chief Justice, before you get to that, just to be sure, based on the current trends we're seeing, do you foresee us moving away from jury trials based on the trends?
Well, that is what is in fact happening. Because jury, if you include the gun courts and so on, or the most recent annual report will tell us that jury trials for 2022 contributed 16% of the total number of criminal trials, if you include the gun court and the Supreme Court. So it's what the data is telling us. So you see, so if you have 100%, and of that 100, 16% is judge and jury, and the rest is bench trial. As to whether I know it's an interesting argument to put about persons coming from the prosecutorial background. There are a number of things that people have to bear in mind. Prosecutors, by their training and disposition, and it's something that is constantly reinforced, is that and this is enshrined in case law now, not me making this up, you can look it up. There's a case from the Cayman Islands, I think it's Barry Randall. There's a case from Canada, Stinchcombe, and cases from the Privy Council and from the Court of Appeal that have outlined the role of the prosecutor. And one of the roles is that the prosecutor is not to seek a conviction at any cost. That is part of the ethical considerations for being an effective prosecutor. The prosecutor is actually under a legal obligation now. So in the context of a jury trial, and the judge has either misstated or omitted to point out something in favor of the defendant, the prosecutor is under an obligation to indicate to the judge that perhaps the judge may wish to consider this or that. Whether the judge takes it on board is another matter, but that is what the prosecutor is required to do. The prosecutor is required to make available to the defense exculpatory evidence. So all of those attributes, I would think, prepares the person to be, or insist and constantly remind them to be open-minded and to be fair despite the fact that you're a prosecutor. Whereas with the defense, they don't have similar obligations. The primary obligation is not to mislead the court when you're functioning as defense counsel. So if the judge makes an error, the defense counsel can keep their powder dry to go to the Court of Appeal. If the judge misstates the law, especially adversely to the defendant, the prosecutor has a duty to bring it to the attention of the judge. And the other thing now is that it can be resolved empirically. Again, look at the data. Because common sense would suggest, because the common sense argument is that because you're a prosecutor, previously you're more likely to be biased in favor of the Crown, which means inferential, and it can't mean anything else. You're more likely to be biased in favor of the prosecution, and therefore more convictions. But the data is not telling us that. That's not what the data is telling. So the argument, it sounds nice, but it has no basis in fact. Because what the data is telling us is that you are more likely to be acquitted before a judge than a jury. And there's a good reason for this, Remember that the jury, it doesn't approach evidence. Studies have been done in the United States on this. Jurors do not analyze the evidence in the way that judges do. They really don't. Yes? And then also, the judge has to give reasons, and the Court of Appeal president here will tell you that the Court of Appeal is now insisting on it. So if there's a conflict in the evidence, you have witness A, witness B, and the judge says, I prefer witness A. In the old days, the judge could simply say, well, I think witness A is more credible. Now you have to say, well, why do you think witness A is more credible? So you have to explain. So you have to show how problems in the evidence are resolved. A jury doesn't have to do that. The jury just simply comes back and just simply says guilty or not guilty, or third option, we can't agree. So that is my response to it.
Thank you very much, Chief Justice. Justice Brooks, would you like to weigh in on the matter of the mandatory minimum sentence? And then we're going to go back to the audience and take some questions. Where's the microphone? Okay.
The mandatory minimum sentence has been the topic of at least one judgment of the Court of Appeal, where we have said that it is not inherently unconstitutional, but it may be unconstitutional in specific instances. And a couple of the examples that the Chief Justice has just given, where a person is incarcerated or sentenced to imprisonment for 15 years for a bullet or 2 bullets, and the judge is of the view that the sentencing judge is of the view that that is outrageous in terms of the circumstances of the case, then the judge A has to impose a sentence. B, when it gets to the Court of Appeal, the Court of Appeal can look at the circumstances, and it may or may not decide that in that particular circumstance, the mandatory minimum may well be unconstitutional. I'm not tying the court in any way in respect of that, but that is where the jurisprudence has been leading us.
All right, thank you very much, Justice Brooks.
Morning, I'm Jamila. I'm from TVJ, and my question is to Justice Crooks. You mentioned a lot of statistics as it relates to traffic court, right? Do you think what could have been done to better prepare the courts for what we saw in January or February, given that the statistics says that by the next 3 months we'll be able to clear up the outstanding traffic tickets that you saw? And that's one. And two, for the Chief Justice, you spoke about the delivery of legal services. And during that time, we noticed that a lot of the outstanding traffic tickets, some of them rather, they were from different parishes. The President of the Court of Appeal also said that cost and time is also an issue. Is the court exploring the possibility of allowing persons with traffic tickets in other parishes, and you live in, for example, St. Andrew, I drove to Trelawney, to perhaps pay it at a court in St. Andrew, sort of like a multi-link court, for example, rather than traveling all the way to Trelawney to pay an outstanding traffic ticket, or St. Anne. And if I could squeeze in one more, Kadish. Transportation for inmates who have been remanded. I want to ask Justice Crooks if that has been an issue as it relates to the timeliness of persons being transported to court from remand centers, from lockups, from prisons, etc.
All right, Judge Crooks, you can go ahead, sir.
All right, thank you for those questions. Well, firstly, in terms of the 3 months, I'm not saying that we dispose of all the outstanding tickets within 3 months. What I was in fact saying is that based on what we saw, it's clear that we had to put a strategy in place to deal with outstanding tickets. So that strategy has been put in place. It's a work in progress. So there's an aim to deal with a certain amount of tickets within the 3 months period, and then we can further assess as to what we might need to do, or if that is working, we can proceed with it. That was one question.
Transportation.
Well, no. You had asked something else about, transportation in terms of remandees, whether that affects the work in the courts. Yes, in a nutshell. And actually, that has been a perennial problem from the days I was a clerk of the court, and even before that, the transportation of prisoners. Again, during the COVID period, that problem was ameliorated somewhat in that we facilitated some holding areas, an online platform. I think it's more, or at the time was more utilized with the Supreme Court. Well, out of necessity, we had to do it as well, where basically there were limited bail applications also that were facilitated via the online platform. But yes, that is a problem. Although but we have reached out with the stakeholders, and there has been some improvement. I think the problem is that, for instance, in the corporate area, I don't know if there's any change from the correctional services standpoint, but sometimes the one vehicle or the vehicle would go to the Supreme Court with the prisoners, with the remandees first, and then they would come up to the parish court. And again, I'm saying by way of criticism or anything, but maybe the priority was at the Supreme Court, for instance, with that very involved matter the other day. That would have been a very high-profile matter. There are security concerns. The difference with the parish courts is that more often than not, the persons are held in the police stations that, due to the design of the court structure of the parish courts, luckily for us, some of them are relatively near to the parish court. But yes, the transportation of remandees has been an issue. Although, to be fair to them, there has been some improvement in that regard.
Judge Crooks, before we move on to Chief Justice, can you also explain why, if you receive a ticket in Trelawney and you live in Kingston, you must go to Trelawney to have that matter adjudicated if you have not paid for the ticket at the tax office?
Oh, right. Thank you. And that reminds me of the other question. You had asked what could have been done to avoid what we saw at the traffic court, especially the corporate area traffic court and the other traffic courts island-wide. At the risk of courting controversy, what could have been done is that persons paid their tickets when they were supposed to. I know there are varying reasons why the tickets would have accumulated. Actually, as you asked that question, I'm remembering what your colleague asked about the deterrent factor. And unfortunately, sometimes, as the chief said, if we don't deal with these things in a timely manner, persons don't take them seriously. So what we're doing now in terms of trying to tackle the backlog is to prevent a reoccurrence of that. There, again, it has to, we accomplish more when we work together. When I say together, because this is a joint effort between the Ministry of Justice, the Ministry of National Security, the court system, in terms of reducing havoc on the road and to bring back the rule of law there. But if anything, if any good has come out of this, that the traffic court would more than likely be the poster child, at least at the parish court level, would be the poster child and the template for why we need to go, why we need to work more in an electronic and digital workspace. There were some efficiency and teething pains in terms of the traffic ticket management system, the electronic, and so what we're having instances, as we saw, of persons who had paid their tickets, but we were getting information that they were still outstanding, as a result of which we prefer to err on the side of caution, so we would have been ordering warrants for those persons, because that's really a breach of their constitutional rights. Unfortunately, again, there was some improvement in that, but the unfortunate side effect of it is that we had a backlog of tickets from when the system was not working. Those deficiencies had been pointed out. With the advent of CAD, they were pointed out even more. Things reached ahead when it did. Again, we as judges, we tend to look at the glass as half full. The good thing about spotlights, when it highlights the positive, it also highlights the negative, and it gives us an opportunity to do something about those negatives. In terms of the tickets being paid at the parish in which the offense was committed, well, what you suggested, that's something that can be looked at if the law allows that, but ideally, if you commit the offense within a certain parish, it's a jurisdictional point. So it is actually restricted to that parish. But I'm not saying that can't be done, but we'll have to literally look at the law to see that can be accommodated. Because again, it might seem efficient on the face of it, but what could happen now is that you literally be moving, or look at the traffic court in the corporate area, approximately 380,000 tickets. Now imagine, out of convenience, and I'm not saying that we're not trying our best to serve all the court users, we shift all the tickets from Trelawney, Hanover, and so on. We're going to overburden one more court in the corporate area. And again, we are back to square one. And again, we are, any system comprised of human beings will have flaws. We have, I call the court staff, the assistant clerks, the orderlies, the deputy clerks especially. I call them the unsung heroes in the system. What you saw in terms of how they went above and beyond to try and, although we're telling persons that they were literally misinterpreting how the deadline was to be imposed and the impact on their tickets, but nonetheless they turned up in the wee hours and we moved to serve them. But that is actually a microcosm of what could happen if we do it that way, where you accumulate tickets in St. James, and out of convenience, you shift it to the corporate area, so to speak. I'm not saying it can't be done though, but again, that will tie into us being more efficient in terms of an electronic and digital landscape.
Thank you very much, Judge Crooks. Chief Justice? On the issue of the tickets.
You're satisfied? No, I have nothing to add.
Okay. Very well. Very well. Who has the microphone?
Orville Taylor. RJ Gleaner. Yeah, this is the capacity I'm in here today. Good morning, everybody. It's my privilege to be here. I'm not even sure if I really deserve to be here, but thank you so much for the privilege of speaking to a group of such learned and prestigious individuals. I want to say very quickly that, Chief Justice, I totally endorse the stance that you have taken over, I think, the last couple of years in regard to bench trial versus jury trials. As a behavioral scientist who clearly understands how to manipulate a crowd and how to do things with people's minds, I'm very nervous when it comes to people who who are not trained in the law, administering law. And in any event, when I look at the international data coming from Transparency International, coming from Amnesty International, etc., a number of country practices, the level of faith in the Jamaican judiciary and the level of venality that they speak about puts Jamaican judiciary in an exemplary position. So for all the negative criticism that people may have, I just want to make it clear that Jamaican judges in the hemisphere, certainly better than those in America, the numbers report higher in terms of people having confidence in what the judges do, in terms of corruption, etc., etc. So, having said that, there is something though that spins from that, where my colleague here, Mr. Brooks, raised a question, and I've heard it from the defense attorneys about the genesis, the antecedents of the prosecutors. It's a serious statement, you know, because basically you're making the same kind of statement that they sent Marcus Garvey to jail for, that you're saying that somehow these people have not disabused themselves of their own antecedents and are carrying those biases onto the bench. Having said that, you know what my real problem is? My real concern on International Female Judges Day is that using the same argument about something that you can't change, which is your sex or your gender, you can change the antecedents, some of the antecedents, whatever. You can't change the fact that you're a woman. So where we have the majority of our judges being female, the majority of our lawyers being female, and the majority of students who graduate from the University of the West Indies, that is 75%, being female. And the majority of the judges, I think, were trained, or rather, were trained at a time before we had the Charter of Rights, which is 2011. And therefore, before the Charter of Rights, there was space in our Constitution for female privileging. The Maintenance Act was an earlier legislation was passed. What am I saying here?
Yes.
I am saying we have the same kinds of concerns about possible bias. Because I've heard the female advocates raise the same questions about male domination in male judiciaries elsewhere. Are we willing to make some kind of a statement about possible female bias there? And the second question is a question, no. Why, it might be outside of the remit of this August panel, but why is it that the court that administers the most important resource in this country is a quote-unquote inferior court? No disrespect, sir, but it is not. In Trinidad, the industrial court is a supreme court. In Jamaica, the Industrial Disputes Tribunal has a body of knowledge that I can put together, Earl and myself, we do labor issues. We can put together a body of knowledge and guide people. But it is possible for a parish court judge to lock himself away, or herself away, with all of the biases that people have based on the grand narratives about the society, and pass judgments that don't have any kind of scrutiny externally, because they don't have to put down a whole lot of dictum for people to learn from. And then you expect that you're going to be able to solve some of the questions related to crime. The data coming in from my department, sociology, psychology, and social work, and then had to work with us for a while in the faculty, is that one of the major issues or major antecedents of criminal or multi-criminal behavior is the way in which boys are treated by their mothers, including where they are improperly placed coming from out of a family court. I think we need higher levels of scrutiny there.
Okay. Dr. Taylor.
Yes.
Right, that sounded more like commentary to me, and I'm sure the members of the panel will take that under under consideration, sir, as we look at the operations of the family court. Let me see who has the microphone now.
Good morning, Kimon Francis from the Gleaner. Would you like to go? I could go after you.
Considering that I've traveled all the way from that's another matter. I won't go into that. Good morning. Good morning, everyone. I wanted to make a quick comment about the traffic court and to have got your response. However, my two major questions were to the Chief Justice. But I will still just make a comment with respect to the traffic court that as a citizen who have been a victim of the traffic court, in the sense that I see the traffic court like a Venus flytrap, because I remember the first time I went to the traffic court and I was waiting outside. It was for a speeding ticket, and I had actually taken a photograph of the speed limit sign, which clearly showed that I had not infringed the law. But when I arrived at the court, the policeman at the door said to me, "Boss, just go in and plead guilty and pay the fine and go about your business." And, you know, that's justice denied in my case. So I don't know if the architecture of the traffic court can be so realigned that persons who wish to defend their matter in the traffic court can be given a certain level of respect as against just going and pleading guilty, which means that the traffic court, in essence, is a revenue center. But may I just ask your Chief Justice, sir, in Western Jamaica, there has been a continuing lobby about, especially civil matters, and the extent to which many of these matters have to end up in the Supreme Court because of the amounts of money involved. I know some efforts have been made to increase so that, and also I think there have been a few sittings, if I can't recall, of the Supreme Court. So I would want you, sir, to expand on that and to give an update as to where that is at the moment. And my second question is, I would like to get your take on the business of, or the matter of municipal courts, because I, for one, feel that with so many infractions in the society and with respect to the maintenance of law and order, rather than burdening the other courts, perhaps if each jurisdiction, if each part could have municipal courts which could deal with some of the, you know, regular infractions that we find, like the illegal vending, that sort of thing, sir. I await your responses.
Very well. Let's just say that, Mr. Smith, that I have no inherent difficulties with municipal courts dealing with what you would call minor public order matters, illegal vending, obstructing the sidewalk, that kind of thing. I don't have any inherent problem with that. The question of the delivery of civil justice to the West, I think that is a broader question that you are raising. There is a registry there, but it needs to be in far better physical surroundings than it is at the moment. And this comes back to the question of the infrastructure. And also, it would help significantly, again, if the decision regarding the integrated electronic case management system, if that decision is made sooner rather than later, so that the work can begin in earnest, because that will go a far way in resolving that issue. Because one of the things that Dr. Dennis's report points out is that on the civil side in the Supreme Court, there has been a significant shift in the hearing on a number of matters, particularly applications into the electronic space. So what that means immediately is access to justice is expanded. So it means that the attorney in Western Jamaica will find it less necessary to travel to Kingston for the matter to be heard in order for him or her to participate in the process. So the client can be right there beside the lawyer down in Western Jamaica. And if that is coupled now with an electronic case management system that is efficient and reliable and so on, it means that the question of missing files, mislaid documents, all of those things would be eliminated or reduced significantly, and that will go a far way in increasing the types of services that you are speaking of, because as it stands now, the files have to be moved physically from those that they can't deal with down there. They have to be moved physically from the Western Registry into the Supreme Court, and then the orders or whatever it is sent back down. With the integrated case management, and I'm not saying it is the great cure-all, but it will certainly solve a lot of those issues. So when the judge makes a decision, then in terms of access to the order can be virtually immediate. So the technological input is critical. And I know that down in Western Jamaica, particularly when we get to Hanover, the question of a stable internet is a problem. So Hanover, Westmoreland, St. Elizabeth, Trelawney, those areas where you have a problem with internet connection, especially when you tend to leave the coast and go up in the hills. If you've been up to Ulster Spring recently, where in addition to the bad roads, the internet up there is virtually zero. So those are some of the ways now in which we can improve access to justice. And it's not just a pie in the sky. What it really means is that litigants who have to travel to Kingston, less risk of being in accidents, no toll. Even if they're dissatisfied with the judge and they want to go on appeal, because one of the things that's happening in the Court of Appeal is the acquiring equipment to make the electronic hearings more efficient and better qualitatively. So in the future, and that future is here in terms of the technology, it's a matter of implementing now. So you can actually look forward to a future where you can go quite literally from the parish court straight to the Privy Council, and you never leave your living room. So that is what the technology allows us to do. But in terms of the court coming down to the west, again, I have no problem with that, which comes back now to the question of the infrastructure. To have a proper infrastructure for the court can operate to deliver legal services. And I think court buildings are important, despite the benefits of the technology, because the court building represents the authority and the presence of the state. And it is important as well that the symbols of justice and the symbols of governance be present in communities, so that governance is not just seen as something remote and out there, but it is present in the form of police stations, present in the form of courthouses. This is why outstations are important. So it's not just a matter now of it is more convenient to come down to the head station, but the feeling that justice comes to people in their communities is also important.
May I just indulge in 1 minute? The matter of the Justice Center for the Montego Basin, do we have any update on that?
The update is that no land has yet been acquired after, 10 or 15 years of searching. But it really needs to be done. And so we're talking about a major trial center now. It could be based in Montego Bay, because they have excellent roads now going down to Hanover, and they have the regional gun court that takes in the cases from Westmoreland, Hanover, Trelawney. So if you have a major complex there, both civil and criminal matters can be dealt with there for the western section of the island. And if that court is equipped technologically, it means that persons don't necessarily have to come onto the court building. So you can join me in trying to persuade those who need to make the decisions to do so.
Thank you very much.
Morning again, Kimon Francis from the Queen. Perhaps, you're welcome. Perhaps this is a question for Chief Justice. Last month, the Justice Minister proposed an increase. He brought 2 bills to Parliament proposing increases to the mandatory minimum sentences. Defense attorneys and the opposition raised concerns that this might cause the backlog in the court system to balloon. Are there any concerns on the part of the judiciary in this regard?
Well, there would be a concern because, again, human beings respond according to the incentives presented to them. If moral arguments had worked all the time, as I said, crime would be no more. You know, religion has been around now ever since human beings appeared on the face of the earth. And virtually all the religions preach good living, righteous living, don't do certain things. If those things worked, then we wouldn't have need for lawyers and judges. But we are where we are. So if I'm a rational person, and I am 21 years old, and I am charged with the police for an illegal possession of a firearm. And when I speak to my attorney says, well, young man, if you plead guilty, it's 15 years. If you go to trial and the judge is benevolent, you still end up with a minimum of 15 years. If you don't go through a trial, you don't increase the possibility of an acquittal. But if you go through a trial, you increase that possibility. So as a rational person, what decision would I make at 21 years old? So that is it, you know. And so now, we anticipate that the gains that we have made in terms of clearance rate and so on, I expect to see reverses in that, especially with the rural circuits. When we spoke about the rural circuits, they sit 9 weeks for the year or 12 weeks for the year. So it means that any matter that isn't done, say in this term, is going to go down to sometime around June and July. Next time after that is November, December. So what are the things that can happen in the meantime? Witnesses, unfortunately, may pass on. Witnesses may migrate. The exhibit may be, all of those things that count in my favor, you know, if I'm a 21-year-old. So it suits me to go to trial because the chances of, the longer it takes, the chances of things going wrong increase as well. So an irrational thinking person wouldn't enter a plea at 21 years old for 15 years. So there's no incentive there. What other jurisdictions have done is that, I think in the Cayman Islands, they have done this, actually incentivize the process. So what they say is that, notwithstanding the minimum, if you plead guilty, then this is the range, which is significantly lower than the 15. But if you go through a trial, then now you're starting at 15. Then now a rational thinking person is going to say, well, this is something to give serious consideration to, but if it doesn't matter in the final analysis, then why are you going to enter a plea? Because the lawyer can simply say to you, or advisor, put the crown to proof. And all sorts of things can happen, and the lawyers here will tell you sometimes the exhibit can't come into evidence for all sorts of reasons.
All right, thank you very much, Chief Justice. Dion, I think, has her hand up, and then Andre Earl. We'll come back to you. Okay, Andre is going first, and then we'll come back to Dion.
Thank you very much. Chief Justice, this question is for you. What's the current timeline for the resolution of a civil case now, on average, in the Supreme Court? And that's a regular trial matter like a personal injury. And when is your best estimate as to achieving the target of the resolution of matters within 2 years in the civil court, in the Supreme Court? That's the question for you, Chief Justice, and for President Brooks. The Court of Appeal currently sits till 1 o'clock. What is your take on the court sitting till 3:30, from 9:30 to 3:30, with Fridays off for the purposes of writing judgments?
All right, so Chief Justice, we'll start with you and then come to President. Dr. Dennis will also ask you to weigh in on some of the data in terms of the civil side of the Supreme Court following Chief Justice.
Well, I got the report from Dr. Dennis last week. I think it's what, 4 years? I think it's about 4 years for the civil matter to come to an end from filing to final disposition. Now, our time standard is 24 months. But when we brought down Justice Carol Barnaby, she did an extensive review of the processes following the rules in the Green Book, the Civil Procedure Rules, and also look at what was happening in practice. And what we found is that the very rules themselves and the way that they have been operating actually militate against a 24-month period, in that when the claim is filed, it starts in January, the person, and use an extreme case though, the person has up to 6 months to serve. So maybe they can't find the defendant or whomever it is to serve. So they serve sometime in May, June. That person has a further, depending on where they are, 42 or 50 plus days. So you are now down into July, August. Then depending on the nature of the case, when that comes in, the defense comes in, automatic mediation. So you add on to that now another 3-4 months. So you're gone about 9-10 months out of the 24. Then if mediation fails, then it comes back now to the judge, and then you start the process now of case management and so on. And so what we have found is that the actual rules themselves and the way that they have been operating actually breeds inefficiency. Now, one suggestion has been to bring down the time from 6 months for service to 3 months, but that's a matter for discussion. We have also found that the mediation process, in terms of just using the reports that come back to the Supreme Court, we are not saying that persons have not resolved it outside of the formal process, but in terms of the actual returns, it indicates that the success rate is somewhere around, was it 16%? 16%. And so that has prompted now a review as to whether there should be mandatory mediation. And I think the consensus is that there should not be mandatory mediation, and what should happen is that the matter comes before a judicial officer as soon as the defense comes in, and then the judicial officer will make the determination along with the parties as to whether it is an appropriate case for mediation, and that would eliminate one of the applications that we have of applying to dispense with mediation. Now, we also have a high number of adjournments, and Dr. Dennis will tell you more about this, for claimants to serve documents. I think that is a very high percentage of the number of adjournments. So those are things now that when you look at the entire process contribute to the 4+ years. And the other thing too, which I learned a nice term from Dr. Dennis about 2 weeks ago, it's called the Judicial Flexibility Index. And what that measures is the likelihood of a judge granting an adjournment. There are people who actually study these things, you know. So they can actually look at an individual judge, and based upon the record, you can actually calculate the likelihood of the judge granting an adjournment. So the measure is between 0 and 1. So the closer to 1 you are, the more flexible you are in terms of your adjournments. And the closer you are to 0, the less flexible you are. So all of those now are factors that impact the disposition, the speed at which cases can be disposed of. So if we cut down on the adjournments, if we cut down on the failure to serve documents and so on, I think we can get down to the 24 months. In fact, we have to get down to the 24 months because, and get lower, because that is one of the things that affect us globally when we look at the ease of doing business. That's a report done, I can't remember the name of the institution now, but every so often, I think every 2 or 3 years, they look at the processes in the civil litigation, civil division of courts across the world, and they come up with what they call their ranking and so on. And Jamaica has consistently been ranked low down on that. And one of the reasons is the length of time, that's one, and two, the absence of the technology so that persons can file electronically and so on. So I think that it is within reason. The encouraging thing, however, is this. Notwithstanding all of that, if you looked at the data in 2021, the clearance rate was about 20-something%. Last year, it was 78.90%. It was an increase of 52.19% in 1 year. So it shows the possibility. And currently, we have a program where we are identifying dead cases. Some cases, they just come into the court and they stop. So we have identified so far about 3,000 to 4,000 of those cases that just came into the court, and nothing has happened for the past 18 months. So once we clear out all of those cases, and if in the appropriate cases, the judicial flexibility index goes closer to 0, and the defendants file their documents in time, we can get to the 24 months. And I would say that can happen within the next 18 to 24 months.
All right, thank you very much, Chief Justice. President.
Thank you for the question, Mr. Earl. It requires me to answer by giving a little bit of how the Court of Appeal works. To start though, we do sit in an afternoon on occasion when the circumstances demand it. Court will sit in the morning, case isn't finished or has to be finished for a particular reason, and so we'll continue into the afternoon to have it done. The system, however, is not just hearing arguments in court and writing the judgment. You have to prepare for hearing the case. In recent times, especially for the civil cases, you'll find that judges will get a file, which has 3 or 4 inches of paper. And on occasion, the average is we get six cases to be heard during the week. We get our cases ideally by the Monday before the week of the hearing, certainly by Tuesday morning, and we have to start preparing the case for hearing for the following week. So that the afternoons are what are used for not only reviewing what you heard in the morning, but also starting to prepare for the next week. So that is why we have to restrict our hearings to the mornings, and so that we are able to follow what you are saying the following week.
All right, thank you very much, Justice Brooks. Dr. Dennis, if you could just quickly tell us about some of the data that you've seen coming from the civil side of the Supreme Court in the just completed annual report for the Supreme Court. And of course, members of the media can access that on the Supreme Court website momentarily. So just briefly, Dr. Dennis, just some of the data that you've seen coming from that.
Sure, thank you. The Chief Justice has summed up some of the statistics, showing great command of the statistics. The Civil Division of the Supreme Court has traditionally had a very low clearance rate, as the Chief Justice mentioned, typically averaging between 20 and 30% annually. which means that really for every 100 cases that are filed, new cases that are filed, the Civil Division traditionally only disposes of between 20 and 30 cases for every 100 new ones that are filed. Obviously, that means that if you are doing that long enough over time, you build up a substantial backlog, which is the case for the High Court Civil Division, that there is still a substantial backlog. But what we would have seen in 2022 in particular is that a number of projects and operational reform initiatives were pursued by the Chief Justice and the team, which have resulted in a targeted approach to dealing with backlogged cases, both active and inactive backlogged cases. And so the giant leap that the Chief Justice would have mentioned in the clearance rate of about 52 percentage points gain, which is on record, that's the highest clearance rate that the Civil Division of the Supreme Court would have recorded, on record, which is 78%. So it's a result of structural reforms. The 2 years that is used to classify a case as being in backlog is guided by international standards. As the Chief Justice would have mentioned, the current processes do not necessarily lend themselves to us achieving that number. And so that is why the reforms that are being pursued, which the Chief Justice would have mentioned, are necessary to reduce the interval time between events along the case flow continuum. And so one of the next steps needs to be for the Civil Division to set what we call intermediate time standards. So we have the 2 years as the global standard. We need to dispose of a case within 2 years. Currently, we're taking between 4 and 5 years on average to dispose of a civil case. Closer to 5 years, more so. It needs to be down to 2. So what needs to happen is that we need to set intermediate time standards, which means between each major event on the case flow continuum, there needs to be precise time standards defined towards attaining the 2-year mark. In terms of a projection, the Chief Justice would have given an indication of the possibility of accomplishing this within the next 18 months, 2 years. I think that is, it's doable with a lot of hard work and persisting with the deep structural reforms that are being pursued in terms of the way in which the registry operates. So we ended 2022 with a clearance rate of 78%. As I said, that's the highest clearance rate for the Civil Division on record. What that means is that for every 100 new civil cases that were filed, 78 cases were disposed. That's a sign of progress. But the reality is that in order to start really making serious inroads into the backlog, or any inroad into the backlog at all, the clearance rate needs to be over 100%. And in the case of the Civil Division, it needs to be significantly over 100% for a good period of time in order to eliminate the backlog. But it's a good sign of progress, and I just want to say, Mr. Fletcher, that another very important metric which is showing good progress in the Civil Division is the hearing date certainty rate. That is the probability that a date set for a hearing or a trial, if we're looking at trial date certainty, will proceed on schedule without being postponed. In 2022, the rate was over 80%. This is an 8 out of 10 chance that a hearing date set will proceed on schedule. And one of the things that have contributed positively to that is that we are now having a larger proportion of our hearings in the Civil Division taking place virtually, which, as Chief mentioned, increases the access to justice and really does, it limits the argument that physical resources are a constraint on total productivity as far as hearings are concerned.
All right, thank you very much, Dr. Dennis. Let me just balance that argument quickly, and you will understand why I need to do that. On the criminal side, Dr. Dennis, can you just provide for us and for our participants this morning the number of courts that are actually backlog-free, while we understand that the civil side maintains its backlog?
Yes. So we have a few courts in the island. So backlog-free is a utopian concept. You know, there's it's not likely that you will have a court with a completely zero backlog. So it's a utopian concept. However, we do have courts that we would classify as very near backlog free, technically backlog free based on the very limited number of cases that are over 2 years old. And one of our greatest examples is the Hanover Parish Court. They have literally under 10 cases that are in backlog, criminal cases, which is a remarkable accomplishment. The St. Mary Parish Court is also one such court that has made quantum strides and also has only a handful of criminal cases in backlog. The Gun Court, which I think is a shining example of what deep and persistent structural reforms and leadership can produce. The Gun Court, the High Court Division of the Gun Court, which was once a heavily backlogged entity, once with very modest clearance rates, now enjoys consistently one of the highest clearance rates in the entire judiciary. I say one of the highest clearance rates, we're talking consistently over 100%. I mentioned earlier that in order for the Civil Division to start making any inroads at all in the backlog, we need to start having average clearance rates of over 100%. The Gun Court has now been doing that on the trot for over 6 years. As a result, what we have seen is the case backlog being substantially reduced to the point that it can be classified as a technically backlog-free court.
All right.
So those are some examples.
Thank you very much for that, Dr. Dennis. Where's the microphone now?
Thank you. My next question is to you, Chief Justice. With respect to the technicalities involved in gang trials, and I know Madam Chairperson asked us to avoid certain questions, but I'd like to know from you whether you think there is improvement in the investigation arm of the state.
Well, we'll have to await the outcome when the case has run its course, because there's still some way to go in terms of completion of that matter, and then we'll have to see what the Court of Appeal and possibly the Privy Council make of it. But speaking generally though, what the cases have shown, again, is the need for a dedicated court, and a court designed now to deal with matters of that nature. The cases are resource intensive in all respects, in human resource, technological resource, space. So you have to have the equivalent of, as I said, the courtroom meeting a television studio. And because as it stands now, you have two courts at the Supreme Court joined using technology to function as one courtroom, but those two courtrooms would normally have been used for jury trials. And since the Minister of National Security has been advising us for the last few years that there are, over 200 gangs, I think it was said, operating in Jamaica, assuming that the police become very efficient at their task and persons are arrested, you have to have somewhere to try them. So if you're going to be utilizing two courtrooms for jury trials to try these cases, then where are the jury trials going to be heard? So that is why, as I've been saying, that there is need for a specialized court for that purpose and equipped with all the appropriate technology to manage those kinds of trials, so that the plant at the Supreme Court can be utilized now for the jury trials that we still have.
More specifically, though, do you see improvement as it relates to investigation cases?
Well, I can't comment on that at the moment.
Yes, the matter remains before the court. It's not yet complete. Where's the microphone now? I have a question here for you, Chief Justice. What are the steps being taken or have been taken to protect witnesses in Jamaica while the microphone moves to the next person?
Oh, so the steps. Well, that is normally a function between the JCF, the Ministry of Justice, and the Office of the Director of Public Prosecutions. I know that there is a witness protection program, and as to the details and the mechanisms of it, I don't know, but it comes back to the point now about getting the cases through quickly, because when persons are on the program and the case takes 4 years and 5 years, persons develop, some of them, diabetes, hypertension, glaucoma, cataract, you name it. And if they're on the program, then the state has to be picking up all of those costs. And the longer it continues in the witness protection program, is the higher these costs are. So efficiency, come back to the point of completing the cases quickly, getting them through to final hearing in the shortest possible time. So that the witnesses, because to ask a witness to be just waiting around for 2 or 3 years is a significant time. So they lose employment, yes, opportunity to earn, all of those things are affected, and the families are disrupted, the lives are disrupted. It's a very disruptive process. So efficiency and speed have to be the order of the day.
All right, thank you, Chief Justice. Mrs. Cameron Anglin, I think this one may be for you. What is to be said of service delivery across the courts? And then we're going to Jamila, who has another question.
Thank you, Mrs. Fletcher. Well, certainly we have increased our efforts in customer service across our court system. We have continued to and will continue to train all our frontline staff in customer service. And that's an ongoing process, because people will come from time to time and people will leave. We also stress the pillars of customer service to be highlighted in our courthouses themselves to remind persons. We engage the staff as well in staff meetings to remember the tenets of our customer service charter, which is available on our website in terms of our time standards and generally how we treat with members of the public. We continue to reinforce that because we understand that the court is not a place where people come to have fun. And we tell our staff members this all the time. We're already receiving members of the public who are highly stressed and are there to resolve disputes. And so the way we treat them will determine how they come to respond to our service before they even get into a courtroom. So it's a matter for us that we take very seriously. We go beyond just talking. We also certify and train them at international standards. And that is a key pillar of our strategic plan, which we remind our staff about, and we continue to emphasize every year and every month and every opportunity that we get across our judiciary.
All right, thank you very much. Jamila has a question.
Yeah, morning again, Jamila. Still morning. Yeah. To Chief Justice, given that this recent anti-gang case was resolved, I think 6 months shy of the 2-year period, right? Do you think more defense attorneys would want to have judges only trial now, being that I guess I'd want to say that you've done it within that specific time period? And 2, is there any cases scheduled for 2026, 2025? What's the latest trial date now that you have?
There are matters that have gone up to, what is it now, 2025, 2026 or thereabouts. And I think the same for the criminal cases. Now, with regard to, again, these types of cases, I can't speak to whether attorneys will be now more prepared to take on bench trials, but what I can say is that we'll be looking at how these types of cases are managed because they tend to be complex. Why complex? Because the law itself is complex, and we are, until the cases begin to go through to the Court of Appeal, a lot of the jurisprudence is going to still be in doubt in quotation marks. And so the question of managing them to get them through quickly becomes of prime importance. So we'll be looking at practice directions targeting these kinds of cases and how they are managed to get them through in the shortest possible time, bearing in mind that some defendants have been in custody for some time. So again, the need for efficiency all around, and the question now of the adjournments. I think I had some information here, I think, on yes, in the Home Circuit Court, the data indicate that of the total number of adjournments, 75% of the adjournments arose because of third parties. That is, persons other than the judge and jurors and so on. So it tells us, for example, top 6 reasons for adjournments: defense and prosecution to engage in discussion. This is actually 253 adjournments for that basis. It's 5.80%. To settle legal representation, 226 instances of adjournment, or 5.2%. Defense counsel absent, 199, or 4.60%. Disclosure, 157 adjournments, or 3.60%. Defense counsel needs time to take instruction, 140, or 3.2%. Statement outstanding, 133 instances, or 3.4%. And this is from a total of 4,354 instances of adjournment. And on what that does is this. So if the matter comes up and it isn't dealt with and it is put for another date, it means that, firstly, that specific time slot was not effectively utilized. So the resources now were actually wasted. And when we say resources, all around, because not just the judges, but also counsel. The cost of transporting the prisoners to court. So all of those things now contribute to inappropriate use of resources. And when it's set for a future date, then you have cases coming in, and so that is how that continues over a period of time. That is why you have the backlog. So I think that if those were the top 6 reasons, there's a whole lot, there's about 20 or so reasons for adjournments, and if those top 6 are managed, you can reduce the average time from, as it stands now, from 36 months on the criminal side to 24. So the key thing is really efficiency, and what is in it for the attorneys is that you will have the opportunity to increase your revenue, your earnings, because if you get rid of the case faster, then you can take on other clients, and then the attorneys will tell you, especially on the criminal side, many of the defendants, when they pay you the fee in, say, 2021, that's it, there's no more to get. And so when the case goes on to 2022, 2023, the attorney begins to subsidize the defendant. So that is what happens. That is why it is not in anybody's interest to have undue delay, not in the defendant's interest. Because even if he is convicted, then he can get onto his appeal, or he can begin to start serve his sentence if he's satisfied with the outcome. And so that is why we keep coming back to the question now of the efficiency for the entire process, from arrest, stages leading up to trial, production of the transcript, getting into the Court of Appeal.
All right, thank you very much, sir. We're coming down and we'll be wrapping up in the next few moments. We'll take a question from Ricardo, and then I have another one here online for you, Chief Justice.
Ricardo Brooks. Chief Justice, this question is largely academic, but could you talk a little bit about why you think the framers of the Constitution didn't give the head of the judiciary the automatic right to sit in the highest local court, which is the Court of Appeal?
Well, I haven't the slightest idea. I think in, I can't remember whether it is Bermuda, but that arrangement is not unique. And even with the reforms the other day in Belize, where I think they brought in a new statute, the Superior Courts Act, I think what they did was to use it as an opportunity to emphasize and to state explicitly that the Chief Justice is the head of the judiciary, but I don't think the Chief Justice there sits in the Court of Appeal. So that arrangement is not unique. Other countries have not done so. So for example, in Barbados, in Trinidad, and in the OECS, the Chief Justice is also the President of the Court of Appeal. In Singapore, the Chief Justice there has the option of sitting as a trial court judge or an appellate judge. So there are, I suppose, different ways of addressing that issue, but our framers chose this methodology, which so far is unique.
Just to add to that, Mr. Fletcher, the Constitution, when it was originally framed, did allow for the Chief Justice, at the invitation of the President, to sit on the Court of Appeal bench. But of course, that was a time when the numbers of judges was very small. We had 3 judges at a time. So the opportunity for that doesn't really occur anymore. In ceremonial cases, he does sit as the head of the judiciary in the Court of Appeal.
All right, thank you very much. I promised just a couple more questions and we're wrapping up. Chief Justice, this one looks like it's for you and the President. Any comments on the steps being taken by the country for constitutional reform?
Comments on the steps?
Right, for constitutional reform.
The only thing that I would say, and comes back to efficiency now, is to, since it is said that they're going to, the first stage is to go to a republic, there's a simple amendment that I think that would increase the efficiency of the court, and that is to permit a single judge of the Court of Appeal to hear procedural appeals, because remember, that was what was intended, but it was found to be unconstitutional. So if the Constitution is amended, and that shouldn't take anything too complicated, it has nothing to do with fundamental rights or anything like that. So if you go back now to what was originally intended when the CPR came in, because the whole idea was that procedural appeals should be dealt with very quickly and then come back, because sometimes the trial is awaiting that outcome. So when you have to bring 3 judges together now, even though albeit that is heard on paper, it's still 3 judges who have to consider it. So I think if they make that, in the context of the scheme of things, simple amendment, then that would go a far way in speeding up the trials in the Supreme Court, especially when there's a procedural appeal. So that could be one of the things that they do at this early stage.
Justice Brooks?
I look forward to the day when the final court is not resident in the United Kingdom.
Okay, sir. Thank you very much. Very brief with that comment there. I just want to go back to something Jamila raised earlier, just to ensure that there is clarity. It is not being said that the close to 400,000 tickets will be adjudicated within the 3 months, but that's what we've counted, and that's what we're now strategizing to have listed before the courts, and to confirm that persons have been getting their dates for court, and those matters are currently being dealt with, in addition to all that Judge Crooks would have said earlier. I'll make one last check around the room to make sure that there are no more questions. Yes, there are no more questions. And so all that is left for me to do this morning is to thank you very much for your participation. As I would have said earlier, the media represents an important stakeholder for the judiciary, and we are interested in continuing this conversation. And as we go forward, we look forward to greater levels of partnerships as you tell the stories that are coming out of our courts, and you take that to the people of Jamaica so that they can in the end hold us accountable to what it is that our mandate is. So thank you all very much for your participation this morning, and we are so grateful that you would have joined us, and we look forward to continuing our conversation with the judiciary.